What do we mean when we say that some leases, some rents are protected whilst others are not? Hi, I'm Daniela. I'm an litigation lawyer specialized in civil law. So, in 1959, just after the end of the Second World War, a law was passed in Malta whereby people who had citizens who had vacant property had to give out that property to other individuals, other citizens who did not have a residence in, due to devastation brought upon by the war. Now, although the law was enacted in 1959, and the intentions of it were that it would be a temporary legislation to help people after the war, that law was never repealed, and therefore those grants remained effective. Now, initially, those grants over properties were intended for a minimum of 16 years. What happened was that at the end of that period, whether 16 years or longer, the lessor, the owner of the property, was obliged by law to convert that grant into a lease, keeping the same conditions including the rent. And that is why we refer to some leases as being protected, because the lessor, the owner, did not have a choice whether to convert it into lease or not and upon the conditions. Therefore, at the end of the grant for which the property was granted, the same conditions were converted into a lease. Now, a law was then passed that if the lease that was being paid was lesser than €185 per year, at that point in time of the conversion, the owner could up the lease to 185, which is still very, very low compared to what a property would attract on the market. The owner could only take back the property by filing proceedings and on three scenarios. One, that the person living in the property had not paid the rent twice, even though he had been called upon to do so, that the person living in the property had caused considerable harm to the property, or that the person living in the property was not using that property as his ordinary main residence. If it were up to one of those conditions, the person living in the property was deemed as a protected tenant and could not be evicted. Especially given that the person residing in the property was a citizen of Malta and was using it as the ordinary main residence. Now, obviously, this was an unfair situation because the owners had a property which they couldn't use for themselves and they were only earning €185 at most per year. Therefore, in 2021, the law was again changed to allow the owners of the property to seek a remedy in court. And they had basically two remedies to seek: either to evict the person living in their property or else to up the rent. Now, how has this been decided? So once proceedings have been filed, there is what is referred to in the law as the means test. Basically, the person living in the property is obliged by court to present what he or she or they have earned in the year previous to application, so the income, and to present statements as to their capital in the previous 5 years before the application. Now, when we refer to capital, we mean either property, as in buildings, vehicles, boats, cash, money deposited in banks, as well as financial instruments, stocks, bonds, shares, and so on. The person residing in the property has to present 5 years because if they had gained property and they transferred it, then the court would still take it into consideration. Now, the law defines what a person should have as income and capital for each age bracket. If the person's income and capital fall within the bracket defined by law, we say that the person meets this, and therefore that person is considered as a protected tenant even today. If the income or the capital is higher than that specified for his or her age bracket at law, then the person has 2 years to evict the property and find a new home. And then that property goes back to the owner, whilst also receiving compensation for those 2 years. Now, if the person residing in the property is a protected tenant, then the court will then send an architect onto the property who will evaluate the property and the state in which it is and the rental value, and will then determine the rental value of the property according to a free and open market. However, the law limits how much the increase by which the court can up the rent up to 2% of the value it would attract on a free and open market. And therefore, we can see that even if the rent is increased according to law, it is still very, very low according to what a property it earns, what a property would attract on a free and open market. And that is why there have been a number of constitutional cases declaring such law as unconstitutional. Still, that law applies today, and we see cases of the sort being filed every day. The owner of the property can only ask for the rent to be reconsidered if 6 years have passed since the court has given judgment and has increased the rent, or there has been a substantial change in the circumstances of the person living in the property, such as, for example, the person inheriting a property or the person winning the lottery, and therefore those change in circumstances allow that person living in the property to have an alternative place of residence. I hope you have found this information useful. There is much more that can be said on this subject. If you do have any questions, please do leave your comments or questions in the comment sections below. Thanks for watching.